At the conclusion of this lecture, you will understand what is meant by tort, understand the tort of passing off, and understand the tort of negligence, duty of care, and its breach. A tort is a wrongful act against an individual which gives rise to a non-contractual civil claim. The most common tort is the tort of negligence, which imposes an obligation not to breach the duty of care, that is, the duty to behave as a reasonable person would behave in the circumstances, which the law says is owed to those who may foreseeably be injured by any particular conduct. Therefore, tort consists of an act or omission by the defendant which causes damage to the plaintiff. The damage must have been caused by the fault of the defendant and must be a kind of harm recognized as attracting legal liability. This model can be presented as follows: an act or omission plus causation plus fault plus protected interest and damage can result in liability. Passing off is governed by the law of tort. Passing off is usually found within the business world and relates specifically to a misrepresentation made by one party which damages the goodwill of another party. The idea here is that trader A is not to sell goods under the pretense that they are the goods of trader B. The goods or services in question must have goodwill attached to them. This specifically means that the goods will have a particular identifying features or specifics that will enable members of the general public or a specific section of the general public to associate with those particular goods or services. There must be a misrepresentation on behalf of the defendant that will lead or be likely to lead those members of the general public to believe that the goods offered by him are in fact the goods or services of the other company. There is no statute concerning the law of passing off, which has been developed in the UK solely by case law. Duty of care refers to the circumstances and relationships which the law recognizes as giving rise to a legal duty to take care. A failure to take such care can result in the defendant being liable to pay damages to a party who is injured or suffers loss as a result of their breach of duty of care. Therefore, it is necessary for the plaintiff to establish that the defendant owed them a duty of care. The existence of a duty of care depends on the type of loss, and different legal tests apply to different losses. For more on pure economic loss, see the cases of Spartan Steel and Alloys versus Martin and Company and Hedley Byrne and Company versus Heller and Partners. Before 1932, there was no generalized duty of care in negligence. The tort did exist and was applied in particular situations where the courts had decided that a duty should be owed. For example, in road traffic accidents. In Donoghue versus Stevenson, 1932, Lord Atkin attempted to lay down a general principle which would cover all the circumstances where the courts had already held that there could be a liability for negligence. The facts of this case were: Mrs. Donoghue went to a cafe with a friend. The friend bought her a bottle of ginger beer and an ice cream. The ginger beer came in a dense bottle, so that the contents could not be seen. Mrs. Donoghue poured half the contents of the bottle over her ice cream, and also drank some from the bottle. After eating part of the ice cream, she poured the remaining contents of the bottle over the ice cream, and a decomposed snail emerged from the bottle. Mrs. Donoghue suffered personal injury as a result. She commenced a claim against the manufacturer of the ginger beer. This was held in the House of Lords by Lord Atkin. Her claim was successful. This case established the modern law of negligence and established the Neighbour Test. The rule that you are to love your neighbour becomes, in law, you must not injure your neighbour. And the lawyer's question, "Who is my neighbour?" receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. Who then, in law, is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. It can be seen that this neighbour test for deciding the existence of a duty of care is an objective rather than a subjective one. It is not a matter of what the respondent actually considered, but what they ought to have considered. Nor does the test require the contemplation of the resultant effect on the specific individual injured, but merely requires that identity of a class of individuals who might be injured as a consequence of the respondent's lack of care. The neighbour test for establishing a duty of care can be broken down into two requirements. 1. Reasonable foresight of harm. 2. A relationship of proximity. Foreseeability means whether a hypothetical reasonable person would have foreseen damage in the circumstances. Proximity is shorthand for Lord Atkin's neighbour principle. It means that there must be legal proximity, i.e., a legal relationship between the parties from which the law will attribute a duty of care. For application of reasonable foresight in establishing a duty of care, see Top v. London Country Bus of 1993 and Home Office v. Dorset Yacht Company Limited of 1970. For application of proximity in establishing a duty of care, see Borehill v. Young of 1943. Lord Wilberforce embraced the test for duty in the care of Annes v. Merton's London Borough Council. Lord Wilberforce's two-stage test examines whether the loss was reasonably foreseeable and there existed a relationship of proximity. If so, a prima facie duty of care arises. The defendant may put forward policy considerations to negate liability. The first stage was essentially the elements of the neighbour test. However, in order to address the fears of the floodgates, this was subject to the second stage, which provided a get-out clause for defendants, where there existed policy reasons for denying the imposition of a duty of care. The modern test was established in Capo Industries plc v. Dickman in 1990. This was because the previous tests were too wide and could have resulted in a floodgate of cases coming before the courts with false and unfair claims. Lord Bridges' three-stage test for imposing a duty of care, known as the Capo Test. Under the Capo Test, the claimant must establish that harm was reasonably foreseeable. 2. That there was a relationship of proximity. 3. That it is fair, just, and reasonable to impose a duty of care. It can be seen that the first two stages are taken directly from the original neighbour test. Fair, just, and reasonable relates to the same policy considerations under the Annes test. In fact, the Capo test contains the same elements as Annes. The main difference being that under Capo, it is the plaintiff that must put forward policy reasons for imposing liability, whereas under Annes, liability would arise once the plaintiff had established reasonable foresight and proximity, and the defendant had to demonstrate policy factors for negating liability. A defendant will be in breach of their duty of care if behaviour falls below the standard of behaviour reasonably to be expected in someone carrying out similar actions. The test is objective and is known as the Standard of Reasonableness. It requires the defendant to take reasonable precautions, not to eliminate every possible risk. The rules on causation apply to all torts, which require proof of damage. The basic test is the but-for test. This means, would the damage have happened if the defendant had not breached his or her duty of care? Remoteness of damage. Here, the plaintiff must also prove that the defendant's breach is not too remote from the damage. This is a legal rather than factual test. The remoteness test in negligence is reasonable foreseeability. Was the kind of damage suffered reasonably foreseeable at the time the duty was breached? So long as the type of damage is reasonably foreseeable, it does not matter that it is more serious than the defendant could have foreseen. In deciding on the standard to be expected, the courts weigh up a number of factors: special characteristics of the defendant, special characteristics of the size of the risk, how far it was practical to prevent the risk, how common the risk is, what the standard practice is in the relevant field, how obvious the risk is, and potential benefits to society from the activity that caused the risk. In summary, tort is a wrongful act which gives rise to a non-contractual civil claim. Passing off is the law of tort where one party represents that he or she is another party. Negligence occurs after breach of duty of care. Damage must occur for negligence to be awarded.